Doctor's note for work law. Everything you need to know. Sometimes an employee has to take time off work as a result of illness. He or she may have to provide a doctor's note to verify that they were ill. The employer can also ask for a doctor's note when accommodating the disability of an employee. Employers have the right to ask for a note from the physician when an employee takes time off for sickness, but they must apply the policy equally to all employees. An employer can require employees to turn in a doctor's note when they are off for more than 3 consecutive days and cite sickness as the reason. A doctor's note can only state that the physician examined the named employee on a certain date and time and list the dates the employee is to be kept from working as a result of illness. Any more details than that, and the note may be at risk of violating laws that cover patient confidentiality. When an employee needs special accommodations due to a disability, an employer can ask for a doctor's note that verifies the disability and need for accommodation. The Health Insurance Portability and Accountability Act is a set of national standards that protect the privacy of medical records for individuals. It is actually not a violation of HIPAA to request a note from a doctor if an employer needs information about sick leave, workers' compensation, or health insurance. Court cases have established that an employee's personal testimony, combined with some medical evidence, such as a doctor's note, is enough to demonstrate that the absence of work was due to a serious health condition, and the employee is protected by the FMLA's prohibition on retaliatory or disciplinary action related to the leave of absence. Employers should take heed of the court decisions and create a system for handling doctor's notes when employees become ill. States with at-will employment laws give employers the freedom to fire someone, even if they're sick, and has adhered to company policy with a sick note. It's up to the employee to take legal action against their employer if they got fired. In the event the employee requests leave under the FMLA, a doctor's note may be required by the employer regardless of how long the employee anticipates a leave of absence. If an employee is working in a state with no doctor's note laws, the company is free to establish its own policies for illness-related absence. The only time it's illegal for an employer to not accept a note is when the employee has a medical need and is using the FMLA to take time off. According to the Department of Labor, employees are under no obligation to provide copies of medical records or talk about details that relate to their injuries or illnesses. That information is considered private under law. An employer can't fire an employee for filing workers' compensation, nor can they fire them if the employee has become disabled and a reasonable accommodation can be made. If you need help with employment law, you can post your legal need on UpCounsel's Marketplace.